This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Press release on PR Newswire, September 30th, 2020. The Satanic Temple sues over banned billboards. Lamar Advertising Company refuses to post billboards that promote TST's religious abortion ritual. Okay, so this is kind of complicated. Let me try and summarize it. There are laws in the US that make abortion completely legal. And then there are attempts to restrict those rights from various politicians and states and people who believe that abortion should be illegal. This is a kind of cat and mouse game of making a regulation and then having it either modified, struck down, adjusted, or affirmed by a court. And then maybe it goes to a different court or an appeals court or whatever. And this is how it got up to the Supreme Court, and we eventually had Roe v. Wade, which affirmed abortion rights, which are still to this day a controversial thing. Amy Coney Barrett is about to be apparently confirmed. I don't know if it's actually going to happen, but the Senate is attempting to confirm Amy Coney Barrett as a Supreme Court justice. And she is publicly Catholic, and there is concern that her positions on abortion and other rights would shift the Supreme Court to the right and against abortion rights, and that maybe women in the United States will lose their right to choose their abortion rights. Or maybe at least the Supreme Court will say that states have the right to limit abortion rights. So, in an attempt to counteract that, a group called the Satanic Temple, which is, you have to get past the name. I get that it's a very divisive name, you know. It seems to be exactly counter to Christian thoughts of, you know, the higher power of God and the good nature of God. And so it can evoke thoughts of evil and everything, but quite not. The Satanic Temple is actually about empathy, reason, advocacy. They really do believe in confronting hate groups, fighting for the abolition of corporal punishment, equal representation when religious installations are placed on public property, etc. They have fundamental tenets. One should strive to act with compassion. The struggle for justice is ongoing. One's body is inviolable, subject to one's will alone. Freedoms of others should be respected. Beliefs should conform to best scientific understanding. People are fallible. Every tenet is a guiding principle. And because of this, yours truly is a card-carrying member of the Satanic Temple as well. Well, the Satanic Temple has now attempted to overcome abortion restrictions by turning it into a religious right. They have created an abortion rights campaign claiming that the Religious Freedom Restoration Act actually protects the right of their followers to have an abortion when necessary. And they have a whole website devoted to this. And rather than go over this, what I actually want to go over today is how they are suing over these billboards that were banned by the Lamar Billboard Company. This is their press release, and they say that they have sued over allegations of religious discrimination and breach of contract after Lamar has refused to post their designs. Here are the designs. Not a cake, not a baby. Our religious abortion ritual averts many state restrictions. Abortions save lives. And there's some facts here. And then here's one about what if abortion had been an option? And here's, I don't know who that is, holding up a picture of Hitler. You know, what if Hitler had been aborted, I think is the connection there. And yeah, some of this is a little bit controversial. The Religious Freedom Restoration Act's intersection with the Satanic Temple's abortion rights campaign hasn't been tested in court yet, so who knows if that's really going to work or not. But hey, they're trying. So what we've done, thanks to LBX Annie for getting a hold of it here, we have found the lawsuit, and I wanted to go through the lawsuit and see what we thought. So this is the Satanic Temple versus Lamar Advertising of Louisiana. And we're going to skip some of these. We read the tenets, we've seen their website, and they note who Lamar Advertising is, and they get into the facts. Several states, including Arkansas and Indiana, set forth legal requirements on how, when, and whether a woman can terminate her pregnancy. TST takes issue with the following requirements when they override a member's religious objection: fetal tissue burial requirements, withholding of medical information, state-mandated medically unnecessary procedures, mandatory waiting periods, mandatory counseling, unnecessary ultrasound, and required listening to a fetal heartbeat. Because these restrictions substantially impact its membership's bodily autonomy, TST takes the view that the restrictions substantially interfere with the third tenet: one's body is inviolable, subject to one's will alone. Moreover, some of these restrictions conflict with TST's understanding of the best scientific understanding of the world. TST thus holds the view that compelled adherence to such restrictions substantially interferes with the fifth tenet. Belief should conform to one's best scientific understanding of the world. One should take care never to distort scientific facts to fit one's beliefs. Several states, including Arkansas and Indiana, have adopted a statutory mechanism to challenge regulations that substantially interfere with religious beliefs and practices. See Arkansas's Religious Freedom Restoration Act and Indiana's Religious Freedom Restoration Act. On August 5, 2020, TST unveiled its religious abortion ritual, which includes the abortive procedure into a sacramental act that confirms the right of bodily autonomy, wards off the effects of unjust persecution, and reasserts as ideals the dual paths of reason and confidence. Pursuant to the above statutory mechanism and 19 substantially identical ones, TST holds the view that its membership in Religious Freedom Restoration Act states can demand exemptions from the above legal requirements to the extent that requirements purport to override their religious objection. This is exactly the same kind of thing when people use religious freedom to override, say, vaccine laws or whatever. Well, here, the Satanic Temple is trying to use the religious freedom to override these limitations to the right to obtain or terminate your pregnancy. TST is excited to spread awareness about this progressive statutory framework and its membership's rights to religious exemptions from abortion restrictions. To spread awareness, it engaged a marketing firm called Seedex Inc. to design and place billboards about TST and its abortion ritual. Critical to TST's marketing campaign was the placement of the billboards. The billboards need to be in high traffic areas and need to be located around fake abortion clinics. Fake abortion clinics, known as crisis pregnancy centers, are clinics that offer pregnancy-related services to an unsuspecting layperson. This would include abortions. But they will do anything to deter the patrons from obtaining an abortion, including shaming, deception, manipulation, and intimidation. Of importance to this litigation, there are fake abortion clinics in Fayetteville, Springdale, Jacksonville, and Little Rock, and several in Indiana. TST objects to fake abortion clinics as an improper bait and switch, and as an affront on the sacred right to be free from oppression. To that end, TST intended to place billboards announcing to every prospective patron of fake abortion clinics, "We are with you." With the aid of Seedex, TST identified suitable billboards in strategically targeted areas, those in high-traffic areas, and which either face fake abortion clinics or were en route to them. Lamar owns all of the suitable billboards. So they engaged in contract negotiations. They discussed by telephone the above-described advertisements. So Jacqueline, the CEO of Seedex, notified Tom of Lamar that the advertisements needed to be in the above targeted locations and would be pro-reproductive rights in nature and would pertain to the religious practices of TST. She also notified Tom that Lamar had worked with TST in the past. Tom acknowledged the nature of the advertisement, said this would be no problem. Tom asked for the specific locations of the billboards. Jacqueline emphasized that they would be in these particular locations. September 2nd, Jacqueline emailed Tom with specific locations for approval and stated, "I am also attaching our past campaign with Lamar to show you what creative looked like in the past. This was the past design. Never be hit in school again. Exercise your religious rights and go to the protectchildrenproject.com." Here's another past design. "Our religion doesn't believe in hitting children." So this is against corporal punishment. On September 4th, Jacqueline and Tom confirmed the subject locations. On September 15th, the parties entered into a valid enforceable contract on a form prepared by Lamar, wherein Lamar would place several billboard designs advertising TST's abortion ritual at the subject locations for a period beginning September 28th, ending October 25th. They would pay $16,387 for the placements. One of the billboards is in Benton County, Arkansas. The contract, like all contracts, includes an implied warranty of good faith and fair dealing. It also purports to grant Lamar a unilateral right to determine if designs are in good taste and within the moral standards of the individual communities in which it is displayed, and purports to permit Lamar a unilateral right to reject or remove any copy, either before or after installation, including immediate termination of this contract. On September 15th, they sent the 5 designs, and Tom rejected all of them. Jacqueline attempted to resolve the objection. She sent the following 4 designs and asked what is Lamar's criteria for approving the billboard messaging. Here are some other designs. Susan, you're telling me I do not have to endure a waiting period when I have an abortion. That's true if you're a Satanist. Our religious abortion ritual averts many state restrictions. And then here are the other ones that we looked at previously. They also looked at some of the previous designs that had been approved. Dear Trump, don't grab my cat. That's pretty good. Take my hand, not my life. Stop Planned Parenthood now. Okay, so that was an acceptable one from a different company. I guess that was an anti-Planned Parenthood. So these are not TST designs, just FYI. Notre Dame, Obama is pro-abortion choice. How dare you honor him, Notre Dame? Okay. Before I formed you in the womb, I knew you, says God. Tom did not provide Jacqueline with Lamar's criteria for approving billboard messaging. Instead, Tom flatly informed Jacqueline that designs were rejected and referenced the contract. The rejection was done in bad faith because Lamar refused to explain what exactly was objectionable, so the objection could be cured. From Cantrell, Wayne & Associates versus Guillaume Motorsports, when, as here, a contract term leaves a decision to the discretion of one party, courts will become involved when the party making the decision is charged with bad faith. There was an email exchange. Jacqueline emailed Tom, we are working to understand how we can accommodate Lamar's policy. Is there anything specific about the messaging or imagery that we should focus on? Tom responded, the content is misleading and offensive. Jacqueline responded, all of the content? In what ways is it misleading and in what ways is it offensive? Can you clarify? Tom said all the content. Jacqueline responded, in order to revise the designs, we need more specific information about what is misleading or offensive. The messaging and content is in line with the beliefs of the Satanic Temple and their religious beliefs, so we can't move forward without an understanding of what characteristics are specifically off base. Tom responded, I'll see if I can get more details. We have not received more details, says TST. So SeedX and TST diligently searched for alternative suitable billboards. They cannot find alternative suitable billboards. They issued a demand letter, Exhibit 2. Good afternoon, I represent TST in its efforts to place billboards. My client is working through a marketing firm who I understand you have been directly communicating with. Near as I can tell, your organization owns all the billboards in the suitable area for my client's advertisements. My client and your organization have a contract to display several billboards throughout Arkansas and Indiana. The problem is that someone in your organization is declining to adhere to the terms of the deal. Ostensibly, the issue is that my client's designs are not in good taste and within the moral standards of the individual communities in which it is to be displayed, but you refuse to indicate what exactly is wrong with the design so the problem can be remediated. It appears that one of 2 things are going on. Your organization could be discriminating against my client on the basis of its religious tenets, which would violate the Arkansas Civil Rights Act, which prohibits discrimination based on religion in contractual transactions. Or your organization could simply be running afoul of the implied warranty of good faith and fair dealing. Every contract imposes upon every party a duty of good faith and fair dealing in its performance in its enforcement. In any event, your organization is bound in the contract to put up the billboards starting September 28th. You can provide meaningful feedback in a timely manner to permit corrections to the designs, or you can put up the designs that have been put forward. You cannot reject them without comment, not without incurring substantial legal expenses at least. Time is a critical factor in this matter. Please advise how your organization would like to proceed by September 24th. Regardless, this letter is your notice to preserve all internal correspondence on this matter, as it will be valuable evidence in the ensuing litigation. And that's true. Once you have notice of a legal claim, you have a duty to preserve evidence, but especially when you've received an express notice to preserve evidence, then you must preserve evidence, or it can later be used against you in court. Let's go back to where we left off. They explain the demand letter, and then they go after Lamar for violations of the Arkansas Civil Rights Act. I'm guessing that's the Arkansas Civil Rights Act. There we go. So the first cause of action is for the violation of the Arkansas Civil Rights Act. Prohibits discrimination because of religion in contractual transactions. If leasing a billboard is a property transaction, the ACRA prohibits religious discrimination there too. And so they go over all of that being a breach, and they ask the court to enjoin Lamar from further violations, which means an injunction ordering them to basically put up the billboards. They also claim breach of contract. Now, breach of contract is just going to be for money damages, which could include attorney's fees, but they did sign a contract, and so then that makes them a party that is required to operate with good faith and fair dealing in the contract. Lamar cannot abuse its rights to object to design elements to override the core purpose of the contract, advertising TST's religious abortion ritual in exchange for money. A party has an implied obligation not to do anything that would prevent, hinder, or delay performance. Contract paragraph 6 is unconscionable because it purports to grant Lamar an unfettered right to reject designs without explanation and without objective measures. This is procedurally and substantively unfair. Unconscionability is typically considered in terms of either procedural substantive unconscionability or substantive unconscionability. Coupling that with Lamar's complete monopoly on billboards and therefore complete immunity from competition, contract paragraph 6 is unconscionable and therefore unenforceable. Lamar did not do what the contract required of it by abusing its right to review design elements in bad faith, refusing to provide TST a fair opportunity to cure the objection, and backing out of the deal. Because it refuses to perform, and because it holds a monopoly on suitable billboards, TST cannot advertise its message. Advertising in this manner is core to TST's organizational purposes. Under these circumstances, TST is entitled to specific performance. Specific performance is an equitable or injunctive remedy which compels performance of a contract on the precise terms agreed by the parties. Whether specific performance should be awarded in a particular case is generally a question of fact for a jury to decide. Alternatively, TST is entitled to a sum of money less the contract price that it would cost to communicate the same message to the same audience. So maybe whatever it takes to accomplish the same goal, building their own billboard, buying the property or leasing the space and building their own billboard, basically. Promissory estoppel is another one, saying that TST relied on Lamar's promises. In other words, they drew up their billboards and everything for the market that they were promised they would have access to, and therefore TST prays the court enter an order finding Lamar intentionally liable for violation of the Civil Rights Act's bar against religious discrimination in a contract or property transaction, find Lamar liable for either breach of contract or promissory estoppel, order compensatory and punitive damages pursuant to the Civil Rights Act, permanently enjoin Lamar from future religious discrimination, order specific performance pursuant to any of the above causes of actions, order Lamar to pay TST compensation in an amount the court finds appropriate, which is anticipated to be less than $75,000 for costs and attorney's fees for having to raise this matter to the court's attention, and for all other relief which the court finds appropriate. Here's the contract with Lamar, in case anyone is wondering. It's about late artwork and copyright and payment terms and service interruptions, and then it says copy acceptance in paragraph 6. Lamar reserves the right to determine if copy and design are in good taste and within the moral standards of the individual communities in which it is to be displayed. Lamar reserves the right to reject or remove any copy, either before or after installation, including immediate termination of this contract. All contracts are non-cancelable by the advertiser without written consent of Lamar, so it's a one-way termination. Breach of any provisions contained in this contract may result in cancellation by Lamar. I don't know, does that make it a breach if they don't accept? Is it TST's breach for giving them something unacceptable? I don't think so. That's a terrible contract. And then that's the rest of the contract. So what do you think of that? I realize that's a bit of a controversial story depending upon your position on abortion rights in the US, but shouldn't at least a religious organization have the right to present its message on a billboard? And shouldn't Lamar have to at least tell them what's going on if it's being rejected so that it can be remedied and cured? Normally in contract law, there is some kind of right to cure. When you're put on notice of some kind of breach, then you would have the right to cure. That's not really written into this contract, so I think there's a default right to cure here. So shouldn't Lamar have to say, well, we don't want to put it up because of this, and then give TST the right to cure that defect? Or is it a terribly oppressive provision that allows Lamar to do whatever it wants to do, regardless of who is paying it to do the advertising? In other words, Lamar gets to put up only messages that it wants to put up, even though it has a monopoly on the billboards in an area. It's a really interesting intersection of two different religious beliefs. On one hand, the masterpiece cake case says that a cake maker doesn't have to make a cake for homosexual people if they don't want to. Maybe Lamar is going to say, well, it's against the religious beliefs of the Lamar organization, but that's not what they said. They said it was against the morals of the area, without any justification. You might remember that there is a case where someone said that a certain kind of adult material was obscene and therefore couldn't be provided in a particular area, and the purveyors of the adult entertainment would be charged with obscenity laws, and the court granted discovery, and that discovery was directed at Google to show who in the area was searching for what. And although the data was anonymized, so it wasn't tied to any particular person, Google was able to show that the people who lived in a particular area were in fact searching for adult entertainment en masse. And so it wasn't considered to be obscene for people living in an area to search for adult entertainment. It was just something people only said in public and then privately still searched for adult entertainment. Kind of like abortion regulations. As a very well-known fact that a lot of people will take a public position, but they still have a private position that is different. You know, rules for thee, not for me, is actually something that happens a lot. Let me know what you think in the comments below. And that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Twitch, and on Floatplane. We are a community-supported channel, so please consider supporting us on patreon.com/ljfrench or sponsors.com/law. In the month of October, thank you very much to our $50 plus supporters: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Stephen, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Jay Dixon, HotGrillsInYourArea, Oscar the Phrophet, Brandyn Abel, Torpedan, IANAL, Cassandra Curran, and Shadow Tycho. And thank you to the $5 plus supporters scrolling on the screen in front of me. All of you are on the LED panel behind me and will be in the description of the videos. I love you all. I will see you in the videos that drop. Have a good week. Bye.